Abusuya lawyer M.Kpebu oye private legal practitioner. Wapa abonten ababetoto bi amane Ghana Bar Association left, center, back and right. Abusuya lawyer M.Kpebu ababeshate omo mat down ababe expose omo enye asem keto akra na ensema lawyer M.Kpebu editu dano. Lawyer M.Kpebu no oche say eye Ghana Bar Association no omonka omanontum na sisi ano omo say President John Dramani Mahama oyobia ososo ensem so anase oyobia oye very calm on attack obia intino enam sa Mahama ne calmness ne composure intino Oba power no obia ohwa na opese odina no ebeba besi no ho during Akuffo government no Ghana Bar omo ahu Akuffo ne criminalities ofori atamu EC ensema ekoso ewo Supreme Court omo ahu ni nyina de ekoso na afei ena omakoma ato MCC ade Mahama aba power se Akuffo tenu ano de okasa ya na waka wano atum okasa ya na waka wano atum enti no omode omano eba besi John Dramani Mahama no lawyer M.Kpebu no ohye process na John Dramani Mahama enemu na ode a suspend Chief Justice Tokono no problem pieni John Dramani Mahama enko say any harm anase onfa any illegalities biya so say ode suspend Chief Justice Tokono into ono lawyer M.Kpebu there everything is on the right track enti Ghana Bar Association for no omonko na omonko pe baby enda momianko na yenkonko ti ensema lawyer M.Kpebu ede etuja medamase.
Lawyer M.Kpebu, thank you for joining us. I know this is a matter that you've been following closely. You've seen the GBA statement. Lawyer Kuji is insisting that yes, they stand by it, that the president's exercise of this particular discretion is unconstitutional because he should have vetted his mind to 296. I've been asking questions about exactly why they take this position, and he says that to the extent that it's a discretionary authority that has been given to the president, he should have vetted his mind to 296. Is it one that you agree with?
I don't at all. I'm diametrically opposed to what Leonard Sylvia Kuje is saying.
Why is that?
Totally opposed to it. It's this matter, more or less, the same question of Article 296 C has been to the Supreme Court, where Amegache versus EC, or no, even the France. Okay, there is France, Transport France versus EC. Where the argument was made that because the EC hadn't published regulations on how they will exercise their discretion, then it means that the elections that were sought to be held, I think that was 2012, will be null and void. That even said that, hey, to give Saka to oppose such an argument will lead to a nuclear meltdown. Nuclear meltdown. That was 2012. Now, ask yourself, from 2012, what regulations have EC brought? All the other constitutional bodies, what have they done? Right? You even look at Ejechum versus Attorney General. So for Akuffo and the rest of the bench, when I say Ejechum versus Attorney General, a case concerning Article 146 proceedings, they said the rules of court committee should come out with fuller regulations, rules that will make the process more streamlined, etc. Ejechum versus Attorney General was about 20 years ago, 2005, 2006. Okay? Till date, it's not been done. About 20 years ago, that's not been done, right? So the Supreme Court has said that the failure to publish the rules as stated in 296 doesn't make the exercise void. It doesn't at all. It doesn't. So let's not kid ourselves. it doesn't make what the president is doing void. It doesn't make it unconstitutional, because the Supreme Court itself has realized that if they were to say so, then society will grind to a halt. So the Supreme Court said there would be a nuclear meltdown. Nuclear meltdown, if you want to say that, for all the public officers who have to exercise their discretion, there must be published regulations and statutory instruments before they do it. So the Supreme Court has answered it. So let's go on, except that as citizens, of course, we have a fair sense of what is justice. If we see something untoward, we'll raise it. The president knows that Ghanaians will not sit down unconcerned. So we are watching. But I think it's far-fetched to say that what is going on or the suspension is unconstitutional. I think that that argument doesn't, there's no merit in that argument at all.
That's what they're saying, that the president should revoke the said suspension on the basis of their argument that it is unconstitutional because 296 was not considered.
That's why I said, so my simple answer is that that answer was given in Ransford, France versus Attorney General, then Parliament. They raised the same thing, that the EC hadn't published regulations on how they will exercise their discretions, etc. And so even we should stop the elections, etc. The Supreme Court said, no, that is not law. That is not law. So this one, I beg to differ from the GBA, my own GBA. And it's curious that the GBA has finally found his voice and is coming here. When Akuffo was misgoverning, we were talking, they were quiet, you see? So it tells you that it's interesting that President Mahama is a better president, he's more accommodating, so now the GBA can wade into such controversial matters. When Akuffo was misgoverning, corruption was at its peak, okay, family and friends, we were on radio, TV, the key points, GBA stood and said, no, they don't want to be involved in such matters. But now that GM is president, they know that he's more tolerant. So for him, they can come and then wade in and make all their arguments. Please, you've seen how our citizens have become very savvy. They've told GBA in no uncertain terms that they are not the conscience of the nation. They lost that position years ago. It's okay, they've come to talk, but they should realize that they lack that authority that they had decades ago. They said they will not involve themselves in national discourse and issues, political matters, etc. So they should know that they no longer command that kind of respect, that kind of authority, the conscience of the nation. No. Now they ring very hollow. So, but it's okay that they've come in. Let them also, air their views. But they should just realize that it's no longer the GBA we thought it was. It's no longer that GBA. But it's okay. They can have their say too.
I see. Council, hold on before. Lawyer Sir, could you, do you lose sleep over this perception that the public has about the Ghana Bar Association because of, you know, the positions you have taken in the past and present about such matters of national concern?
About a lot of matters. Even the resolutions that were put in the public domain today were not centered only on the subject matter involving the suspension of the CG or head removal for that matter. You could see that we talked about Boku, we talked about Galamsey and some other matters. So I would not agree that there is a perception that we've taken a back seat and all of a sudden we want to be on the front line. I would not agree to that. It is true, it's not everything we can talk about. But once we need alliances, we have to talk about.
I see, but you've talked about almost everything that is trending or of national concern in this statement you've issued. So if you take the position that previously it's not everything you could talk about, but now your statement talks about everything that is being talked about now, how do you expect the public to perceive this, especially for the optics for you?
Dr. Albert, you would agree with me that matters like Boku with the happenings, there was no way we could have avoided that. If you follow up closely, Galamsey, since 2021 or so, even 2015, President Benson took his time. When he got intensified I think just after elections 2020. When we were in August 2021, that was a main theme of the our president's speech, 2020 to 2023. So even last year in Kumasi, it was high on the agenda, and he actually said so many things. I came out to even say that he was so hard on the then president that he didn't even have a single reaction to all the things we said about, our president said about guaranteeing his speech. So it is not as if we are choosing and exercise selective as to what we want to talk about. Once it appears topical to us, you hear from us.
Well, so you're also exercising your discretion on what to speak about. I see. Anyway, but let's say, this position that GBA takes has generated a lot of reaction, and in fact, we have quite a number of them coming through thick and fast right now. Professor M.Kpebu has also just posted something on this. Dennis, what's Professor M.Kpebu saying?
Yes, so the man who is in charge of the constitutional review is also raising some questions about the GBA's resolution. So he asks, if the GBA believes that Article 146, as currently constructed, does not provide adequate protection for a target of removal petition in the post-Prima facie phase, its remedy lies in proposing appropriate amendments to that provision. Let me go back a bit. He starts off here by saying that how exactly is Article 296C supposed to apply to a suspension decision pursuant to Article 146? Is it the GBA's position that every time we read may in the Constitution, Article 296 is triggered? So if a provision says Parliament may do X or Y, Parliament must publish regulations under 296C prior to doing X or Y? Really? He continues, and he advances the argument and brings back the case of Transport France as Leonard Senior M.Kpebu was talking about. I see.
And stay with me. Let that be on the screen. And let us, if you can respond to this, let's put this Professor M.Kpebu's position on it. In fact, which is consistent with what M.Kpebu has just stated about how exactly you expect 296C supposed to really, as it were, apply to the suspension decision pursuant to Article 146. Is it the GBA's position that every time we read may in the Constitution, then 296 must automatically sit in?
Not that. We think that this is looking at the special nature of this case, removal of the Chief Justice. That is why the Assembly thought that this should be one of the cases where 296 must be triggered. Because even though France says that if the regulations are not made, it doesn't make the act invalid. We think that this is one of the circumstances in which the regulations must be made. And don't forget, France says that it's not in all cases. We think that this should not fall into that exception, that it shouldn't be made. That is what the Assembly thought. And let me reiterate that even at that Assembly, there were valid opinions and positions on this matter. But just as is done at every meeting, at the end of the day, there must be a position taken. And if that position is taken by the majority, everybody must take it.
Well, you acknowledge the dictates of 146 that this entire process must be in camera.
I agree with that.
But then you are making a demand that the president should publish the Prima facie for all of us to see. Why is that?
Why is that? Because that stage has been gone with. So it's just like a proceedings in a case you are doing. Once the recordings have been done, because this matter will not go back to the Council of State again. They have finished their stage. So whatever proceedings that they have, decisions that they have, I think they can give it to whoever they want to give it to. But it is our right to make a request. It is their right to say that, look, we won't give it to you.
But your request,
premature to ask for them.
But your request must not be in oblivion. I mean, it must be predicated on something. That's why I ask you exactly what is this based on?
It's based on the fact that there's been a decision or there's been an advice that a Prima facie case has been established. That is why the president took the next step by suspending the Chief Justice. So the request at the Assembly was that, okay, can you furnish us with the reasons constituting the establishment of the prima facie case against the Chief Justice relative to the petition.
Well, M.Kpebu, is this particular request having any legal basis or covering to the extent that, yes, GB acknowledges the process must be in camera, but then again, even before the facts, they make the demand that the details of prima facie should be made public for us all to see. Does that defeat the details of 146 in any way, shape, or form?
No, I don't see that one defeating 146 because, basically, because the prima facie stage has already been cleared, it means that as we speak, President Mahama, with the advice or on the advice of the Council of State, has a ruling. It is that ruling that concluded that the Chief Justice has a case to answer. That is, a prima facie has been made, so the 5-member committee should be set up. So it means that there is a document. In one word, what I mean is that there is a document lying down which has reviewed the whole case and said the case should go on to the substantive hearing. So it should be brought out for us to read. Remember, when Professor Akuffo petitioned for the removal of Chief Justice Tokono earlier on in December, and then in January, President Akuffo came out with the prima facie ruling. Yes, so it means that at least, and also you remember the Charlotte Osei matter, the findings of the committee, etc., came out. So far from our past, at least even the Akuffo one, January 2025, is an example that when prima facie was finished, it was released. Yes, so that one, and I'm sure President Mahama will do it because it doesn't help our democracy if citizens cannot access the prima facie ruling. Let's read it, digest it, and see what insights we get from it to guide our paths or to guide our steps going forward. So the release of the prima facie ruling, that one I'm in support, that it will help.
M.Kpebu, I appreciate your time on this, and I also do thank you. This is just the beginning of a series of conversations we're going to be having. I thank you so much for joining us. Kuji, thank you for joining us on Ghana Tonight. And there's another statement that's just, in fact, this is a post, not a statement, because this is generating a lot of reaction. And what's the next? Apart from Professor M.Kpebu, who's been talking about this as well?
Well, so Learned Counsel Addo also reacts to this particular resolution, and he particularly takes issue with the part of the resolution that talks about the reversal of the directive from the acting Chief Justice to have all cases brought to his office for assignment and listing. Mm-hmm. So he begins by even questioning the timing of the releases, i.e. the 26th resolution and then the 24th statement from the GGA, how to reconcile that. Now he comes to look at the specific demands that the GGA, I said GGA, forgive me.
Yeah, you are both a member of GGA and GBA.
Precisely.
So it's okay.
So GBA. So he says that these demands are not only legally flawed and disrespectful, but they also expose a troubling inconsistency in the bar's reasoning. Just days ago, the bar issued a statement that now seems at odds with its own resolution. That was what he tried to point out to the PR of the Ghana Bar Association, how they themselves had indicated that the issue was sub judice and how they wanted the process to be followed. And now they are saying that what the president has done is unconstitutional. Now it goes on to say that by law and long-standing practice, the power to assign cases is an administrative function of the Chief Justice. This function pertains to the office of the Chief Justice, not the individual currently holding the title.
Right.
He continues by saying, the bar's position implies that the powers of the office are personal to the suspended Chief Justice. But when she was in office, the bar raised no objection as she reassigned judges and altered case allocations. Article 14610 of the 1992 Constitution clearly states the President may, acting in accordance with the advice of the Council of State, suspend the Chief Justice, unquote. This means unless there is an advice from the Council of State, the President cannot suspend the Chief Justice. The word may here does not grant discretion to act unilaterally. Once advised by the Council of State, the president is constitutionally bound to act, he must suspend.
Right.
I mean, these are just excerpts of what he's been saying.
It's quite a long one.
And if you've been following Tadio Sorry, he takes issue with some of the things that the suspended Chief Justice has done by way of issuing administrative directives and then practice directions. And when you read, he reiterates the point that when he was raising those issues, he did not see the bar also come to comment on such matters.
And I think that's captured in the Protocol petition that was dismissed as well.
Precisely so.
By the former president, Addo Akuffo. Dennis Pobegwadam is a member of the Ghana Bar Association, a member of the GJ as well. Thank you. And it's my producer. Appreciate you, as always.
Always a pleasure for being here.
For a quick break, because the GBA statement is not just about the suspension. They captured a number of things that are of national concern. Galamsey as well is in there.
Abusia wine and Sama Ekoso, our political highway. So lawyer M.Kpebu and I attend and catch us all to a day emane a year Ghana Bar Association. But I must say, Moje Penecocuti is our audio wing. A day MI, aha, POG Media as well. Abusia unsubscribe, subscribe, like, not share my Afro so and sa into me and Kabi, aha, POG Media so. But I must say.